you. I'd like to first pay my respects to the traditional owners of this country and their elders past and present. And I'd like to thank the conference for having Tina and I address you today. There has been some significant jurisprudence which has, I think, almost turned native title jurisprudence on its head in recent months. And there's also been some judgments dealing with anthropological evidence, including some criticism of the anthropological evidence that was before them. One of those cases, the Mullinaguli case, matter of drill in Western Australia, one of the anthropologists who gave evidence in that case and whose evidence was not accepted by the judge was Dr. Brendan Corrigan, and he has emailed both Tina and I to say that he does not agree with the criticisms of him in that judgment, and he believes that the judge misunderstood his evidence. Now, I think that's enough said on that. This conference is not about individuals, it's about jurisprudence, it's about the law and how that interacts with you as anthropologists. Now, the recent big changes, and they are big changes in anthropology, in native title jurisprudence, commenced with Justice O'Brien in the Malone on behalf of the Western Gungaloo people, where Justice O'Brien slayed the dragon of society which has hexed native title for so many years and which has led people to believe that they have to identify a particular anthropological pre-sovereignty society and all that society's laws and customs, and then follow it through to the present day claimants and show that they are, yes, the members of that society, and yes, they continue to acknowledge and observe those traditional laws and customs. That's a very difficult approach for contemporary Aboriginal people to have to follow in terms of proving their native title, when everyone, including the courts, realises the great disruption that has been caused to Aboriginal societies, Aboriginal groups, by invasion and by colonisation. Justice Malone made the point that Justice O'Brien made the point that the word society doesn't appear in the Native Title Act. It's simply a tool for the application of the definition of native title in 2231 A and B of the Native Title Act. He said, all you look to see, basically, is whether the group before you, before the court, acknowledge and observe a body of laws and customs under which they possess rights and interests in the relevant land and waters. And that's the requirement in section 2231A. And it's directed to the present. So you start from the present. Does this group acknowledge and observe laws and customs under which they possess rights and interests in land and waters? Not do they have moiety systems, do they still speak language, do they still do initiation ceremonies? It's do they acknowledge a body of laws and customs under which they possess rights and interests in the land and waters. That's the first step. And if you go, well, yes, they do, you then ask, well, are those laws and customs traditional? And by traditional, it simply means that they find their origin in pre-sovereignty law and custom. So that's where the relevance of pre-sovereignty law and custom may come in. You look backwards to see when people today are talking about the laws and customs under which they possess rights, can they be shown to have their origin in pre-sovereignty law and custom? And in Malone, the laws and customs which were sufficient to establish native title were the law that the land is inalienable, that the rights and interests are held communally, a person doesn't individually have those rights and interests, and by inalienable, they can't sell it, they can't lease it, they can't get rid of it. They can only acquire that land or those rights and interests in that land by descent. It's the only way they can do it. They have a responsibility under their laws and customs to look after that country, to care for that country. Under their law and custom, they're safe on that country because they can manage the spiritual presences which they believe are in the country. Other people, not part of their group, should seek their consent or permission before going onto the country because of the damage that those spiritual presences can cause. Now, that was sufficient in Malone to have native title recognised. And His Honour also said that the relevant society is the group who today acknowledge and observe those laws and customs. That's the society. And if that's a different society to the one that existed at sovereignty, it doesn't matter. That is an acceptable adaptation of traditional law and custom. So start from the present and don't worry about the fact that they're, do they still have moieties? Can any of them speak language? I mean, fantastic, if those things are present as well. But the laws and customs that the definition is directed to are those under which they possess rights and interests in land. And if they've got laws, in other words, rules, normative rules, they say, well, it's our country for this reason. I get it from my father, who got it from his mother, who got it from whatever. That's the only way you can get it, by descent. No, I can't sell it. I can't lease it. I can't do that. And it's owned by all of this group. I'm not the only one who has rights and interests in this land, and I have a responsibility to care for it. Now, most groups will still have those laws and customs, despite the impact of invasion and colonisation. Most will still have that connection. The people in Western Gungaloo came from Cherbourg. They've been in Cherbourg for generations. Many of them have been born in Brisbane, Rome, or whatever. They'd hardly been to this area, but they knew it was their country and they knew they had a responsibility to look after it. And it's been made easier in recent decades for them to come back onto the country with heritage legislation, native title and whatever. But those basic laws and customs under which they had rights and interests and had a connection had remained. They continued to be passed down, along with, certain spiritual beliefs about the Munnagata, etc., etc. Not a lot, but some. So that was all that Justice O'Brien required, and he said it doesn't have to be the same society that was there at sovereignty. And it's interesting because the Western Gungaloo people, if you trace them back to sovereignty, they came from a larger regional society involving the Gungaloo people, Wadja people, Gurringbal people. I think that's probably about it. So they were a subgroup of those who were Gungaloo, and they were on the western side of what was Gungaloo country. On the eastern side were the Gungaloo Nation people, their claim that was heard by Justice Rangia, and they were unsuccessful. And their evidence was pretty much the same as the Western Gungaloo evidence. So the Western Gungaloo succeeded, whereas the Eastern Gungaloo failed. Justice Rangia thought that it was fatal to the Eastern Gungaloo claim that this pre-sovereignty Gungaloo society had not continued to exist through into the present day. So he was dealing, as far as he was concerned, effectively with a new society. But it's not a new society in the sense that Yorta Yorta was talking about you can't have a new society. What Yorta Yorta meant, if you understand a society is simply a group of people united by their acknowledgement and observance of the same laws and customs. A new society is when acknowledgement and observance of those laws and customs has ceased, and at a later date a group of people try to revitalise those laws or develop those laws and customs. That's a new society because you don't have the continuity. So that reference to a new society is a reference to ensuring that there is continuity, not in the original society, but a continuity in the acknowledgement and observance of traditional laws and customs, or at least laws and customs that find their origin in pre-sovereignty law and custom. Now, Blucher, which was the full court, overturned Justice Rangier's decision. And in doing so, they followed Justice O'Brien's decision in Western Gungaloo and also the recent High Court decision in Stewart. And they too, like Justice Malone, said that the starting point is the present. The definition is directed to the present. So the first question is the question posed by section 2231A, and that is, does this group possess rights and interests in this area of land under a body of laws and customs, under a normative system? That's the first question that the lawyers have to address, so it should be the first question that anthropologists have to address. If that's answered in the affirmative, the question then is, well, by those laws and customs, does this group have a connection? And by those laws and customs is simply a reference to the laws and customs under which they possess rights and interests. It doesn't require any actions to be taken by people in relation to the land. It doesn't require physical actions. It doesn't require anything other than the laws and customs under which they possess rights and interests give them that connection. So, for example, in the Stewart case before the High Court, the fact that the Arabana had been told that this particular country was their country, and the fact that they felt a responsibility for it, even though there was no longer any real physical actions or even spiritual actions being conducted, even though there were no sites on it, no visits, whatever, that didn't matter. They had the connection because under that law and custom which gave them the rights and interests, that law and custom said, that's your country. And they knew it was their country. They'd been told by the elders it was their country. So that's step number 2. That's an easy step. The third step is, all right, they've got a normative system under which they have rights and interests and have a connection to the land and waters. The next step is, are those laws and customs traditional? And the full court explains in Blucher, as Justice Malone explained, Justice O'Brien in Malone, that simply means, do these laws and customs find their origin in pre-sovereignty law and custom? They don't have to be the same. In fact, it's accepted that they will change. Justice Rangier, for example, thought it was an unacceptable transformation to go from ownership by patrilineal estates to ownership by a whole language group, or in this case, part of a language group. He thought that was an unacceptable adaptation. Well, the full court said, no, that's a perfectly acceptable adaptation because the law today clearly has its origin in that pre-sovereignty law and custom. It's not the same, but it clearly has its origins in that pre-sovereignty law and custom. You know, they haven't made it up or picked it up along the way. This is an adapted, transformed, albeit much adapted, much transformed law or custom. Thank you, Louise. And Justice Rangier had accepted that there were laws and customs of the type that there were in Malone. The land was inalienable. It was communally owned. It was acquired by descent, or rights and interests were acquired by descent. There was a sense of an embedded spiritual relationship with the country, and there was some attenuated knowledge of the Mundagata and other spiritual things. Justice Ranger accepted all of that, but he said, but look at what they've lost. They've lost the language, there's no moieties, there's no initiation ceremonies, and all they have left of the dreaming is these attenuated stories. So he put all the things that have been lost up against what have been maintained, and he said, not good enough. You lose. And the full court said that is very much the wrong approach. That is not what the Native Title Act requires. It does not require you to compare what's been kept with what's been lost and then come up with a qualitative opinion as to, well, on the balance of probabilities, they probably kept more than they've lost. What they have lost is not relevant to the definition of native title. What is relevant is what they have kept. And as Malone demonstrates, and as now Blucher demonstrates, these are very broad, generic laws. It reverses in many ways the way that lawyers and anthropologists have approached native title, where there's often been a tendency to start with sovereignty and this search for the holy grail, the society. What's the relevant society? And, the number of hours and days and weeks and whatever that have been wasted trying to work out what's the society that was there at sovereignty, and is that society still here today? You don't need to do that. And yet that's the way we've all done it in the past. But hopefully in the future, we will do what the courts have said, which is to start from the present. All right, well, I think I'll hand over to Tina now.
Okay, so I'm going to talk about something a bit different. Can I just sort of mention in dispatches that Malone number 6 that Vance was just talking about in Western Gungaloo, Richard Martin was the anthropologist on that case, and in the Blucher case, Kim DeRelk was the anthropologist in that matter. And it's important to note, hello Heather, that there have only been 3 fully litigated native title claims in Queensland, and Vance Hughston is responsible for 2 of them. One is Rainbow on behalf of the Kurtaja, which was successful. When I say yes, I should say 3 that have been successful. The second one is Western Gungaloo, Malone number 6, that Richard Martin and Vance did, and then now number 3 is Blucher on appeal. So it's, and this is central Queensland. This is, very settled areas, which makes us all think that going forward, if you can win in central Queensland, you can win anywhere. But, it's a bit like New York. So anyway, we're hoping, fingers crossed, that this kind of big change in the law that Vance is talking about continues on in the way that it has. And I'm here today, in a way, to tell you about changes to the approach to anthropology through the courts, and also to do a recruitment campaign for young anthropologists who should be giving evidence in native title claims. We've got some fabulous people who have been giving evidence for many years. They're here. I won't mention their names. Some of them have given a paper just before mine. But they're wonderful, but we need some new, younger people coming through. And I'm about to tell you about an anthropologist in the Daima on behalf of the Maligno Gawley claim, whose name was Nell Taylor, who, as a very young anthropologist in the circumstances of giving evidence, I believe for the first time, the judge was very praiseworthy of her evidence. And if she can get up there in her late 20s, early 30s and give evidence and be praised by a judge, then you can, okay? So don't be scared. It's not that scary, despite what I'm about to tell you, what the judges said about the anthropologists. Now, what's really important is what the court has to do when they get anthropology and native title reports from you, and the data that you collect, is that it's not necessarily all going to go in. Sometimes there are objections to reports. There are things that can be relied on in reports that can be ruled as inadmissible, or when they're admissible, they're considered to have no weight. And that can be part of the weighing up exercise. And by the way, I have written, these are slides from a longer 10-page paper that I've done, that I've sort of put together. I'm not going to read out all of these things because you can read them in the paper. It's going to be emailed to you. But you can see in Risk in the Northern Territory that that is what the judge, Justice Mansfield, looked at. He talks about facts, how they range and vary in degrees of primacy and subjectiveness, as we all know. A well-known anthropologist who remained nameless said to me last night that we all come to our data collection and looking at previous documents with a sense of bias about us, or our prejudices that we carry with us everywhere we go. We all do it. And it's very hard then, when you go through all these documents and you're doing it on behalf of a client, to then step back a bit and say, right, I've got to be objective about this. And that's not always easy, particularly, and the courts have talked about this in these cases that I'm going to talk about. So one of them is Dharma on behalf of the Malin-Ugorli, which was in the goldfields. And that was a complicated claim because it had two overlapping claims, and one by the Malin-Ugorli. It's in the very western part of the goldfields, and many of you will be aware of the decision by Justice Lindgren in Harrington Smith No. 9 many years ago in the early 2000s that found that Justice Lindgren dismissed a collection of claims over that goldfields area, and as a result, it became a very fractious area. So this was one of the few claims that has been fully litigated in that area. There was the Katchajiban, who were also overlapping the Malin-Ugorli, and then there was a group, a family called the Cooper family respondents, who did not have a native title claim but asserted native title as a different kind of society. They asserted themselves in the eastern part of that goldfields area as Western Desert Cultural Bloc members. So there are the other cases, just quickly, that we're going to look at, and Vance might want to speak to this as well, is Smallwood on behalf of the Bindal, which is another, it's a northern Queensland matter. It's another matter that Mr. Hughston was the senior counsel on that, but that was just to do with a particular ancestor called Lottie and whether she was indeed Bindal. And I'm not going to speak much about Blucher. In my written paper, I put something in about Blucher, but Vance has pretty much covered that now. Now, what are the main themes of these cases? The main themes are that anthropology, of course, unarguably is incredibly important in native title claims. The other important thing is, what does the court's role in ruling on history and anthropology? And Justice Mortimer said in Drill, and this is, I think, a very important quote, it's sort of like, well, we don't really get to the truth, but we try. And she says the court does not decide what the truth is in any absolute sense. I think that's really important for all experts to understand. The court is not, in that sense, the arbiter of history. The court decides whether the party who must prove the necessary facts has shown the facts it contends for are more likely than not to have existed. in circumstances which involve the level of historical reconstruction that these separate questions do, and in that case there was a separate question as to who held native title, that is not only all that is required, it is all that can reasonably be expected. This exercise is carried out on the basis of the evidence adduced and inferences which can reasonably be drawn from that evidence. So, in a way, it's kind of saying, I get all this evidence before me, but I need to evaluate it, and I'm seeking for anthropologists to help me do that because of the importance of that, because of the importance of anthropologists doing their field work and being out on country with the members of the claim group who claim native title in that area, but also, and their familiarity with that, which the court will never get. And then going through all the documents and looking at those documents and then applying epistemology and historiography to those documents, which is crucial in the role of the expert anthropologist in assisting the court, because the court can't do that. That's why you're there. And other people have compared, other judges have compared anthropology to science, and they say it's quite different. But why we all need the assistance of you as anthropologists is to go through all of that detail and then spell it out for us. Why is that document important? Who produced it? Was it before native title? Was it after native title? That makes a difference. You know why it makes a difference, because it could be self-serving. But if it's something from the 1970s in Western Australia and some old fella's telling Kingsley Palmer about something that happened on the Ashburton River and a series of sites that he writes down for his sacred sites work that he did, and I'm actually using a real example, then, and that is really cogent evidence. And you can all talk about that because you can say, that's really real. This old guy was going down the Ashburton River with Kingsley Palmer. And it wasn't about native title. It wasn't even about Aboriginal land rights. It was him saying, this is my sacred sites on this river all the way down, and naming every single one of them. And then saying, oh, and by the way, when I went out with his granddaughter, she told me all the names of those sites and she'd never seen my sacred site report, which is pretty much what happened. So you all have to analyse those documents. You have to tell us why they are possibly real or unreal, and you have to tell us why was that person writing those documents. What was it, a neutral kind of idea that they had when they were writing it down, or did they have a predisposition for not understanding culture or not really understanding what they were talking about, or being told that sites are nothing, not important, there's nothing, which is what Kingsley talked about earlier. Did the person drill down? Did they say, well, why is it nothing? What's that about? Well, why is that one important and this one isn't? Is that important to someone else? Maybe not important to your family, but is this important to, the Jones family? So you have to do that in your reports. And then you have to reflect, and you have to say, according to Dimer and according to Smallwood, that some pieces of information are backed up by other documents, are backed up by the field work. There might be a death certificate that looks a bit dodgy because you can see that the person who was the informant is some dude from the mission. He's not the daughter or the son. You have to go, as you know, through all of those documents and work out what is more reliable than other documents. There might be government documents written by missionaries. All of those things need to be looked at and evaluated, and that's where the court was critical in Dimer, particularly about, for example, there was a report written by Dr. Kane. Dr. Kane, as most of you would know, has a bent about the Western Desert Cultural Bloc. He's very focused on that, and that would I would say would be his expertise. That's the sort of, I would approach him to give evidence in a claim like that. He had not finished a report about Western Desert Ways in and near this area of the Mullinagorley claim. And Daniel Leo, who was the anthropologist for the Cooper family, who were purporting that they were Western Desert Cultural Block people, he relied heavily on Dr. Kane's report. And as the judge said, there's nothing wrong with relying on that report as long as you give it context and analysis and you say, this was an unfinished report. This report was done for this reason. It wasn't done for this case, but it was done for native title purposes at this time. I am going to take some of it with a grain of salt. I've actually discovered in my field work that some of the things that were in Dr. Kane's report have been verified by the clients that I have who took me out on country. Unfortunately, Mr. Leo only did 6 days of field work, so the judge again said, well, that wasn't very helpful. Now, you all have to realise, if I go much further about this, I'm not criticising Daniel Leo. I work with Daniel Leo. I'm telling you what the judge said about his work in the goldfields, that he required him to provide more analysis of the documents that had been provided to him. And he said the Kane report was relied on, and hence there was submissions from some of the parties opposing that case of the Cooper family. It shouldn't go into evidence because it relied too heavily on Dr. Kane, and Dr. Kane's report wasn't finished. The judge said it's got nothing to do with admissibility. Anthropologists, and this is an important take-home, rely on what other people say in other documents, and they rely on what other humans tell them out of court all the time. That would otherwise be called hearsay in the context of law, but there are exceptions to the hearsay rule in relation to native title often, and traditional law and custom is one of them. The other thing is that you all have to go out there and you all have to rely on what other people say out of court and write it into a report, but you need to analyse it and you need to have an epistemological approach to it so that the judge knows that you are looking at all the problems with it and the good things about it as well. And that's what he wanted from Mr. Leo, but he didn't mention that about Dr. Kane's earlier draft report. And he also found that because of this, it presented an image, and I don't know if this is right, but the judge took it that Mr. Leo was being an advocate for his client. And that's something that everyone wants to avoid. At all times when you're giving evidence for your clients, you want to be impartial. And you all know, because you've all read the code of conduct that comes with the court every time that you're briefed in a native title claim. And if some of you haven't been briefed in a native title claim and haven't written reports yet, read the code of conduct. It's really amazing. And as a lawyer, I have to do 10 hours of continuing professional development every year. You're all here doing your continuing professional development. But I just find every now and then illuminating to read the bar practice rules. And I go, oh, really? I didn't quite realise that was in there. It's really helpful before you, I know it's always attached to your brief when you are preparing a report for court, but it is very helpful because it says all the things I'm talking about. It talks about providing an analysis of the materials and then, of course, providing a basis for your opinions, and that's why you're here. That's why you're giving evidence, and that's why you're helping the court, because you have this training and study and experience that the court and us lawyers don't have. And you add so much value to our cases, and we can't do it without you, which is why I'm trying to recruit more anthropologists into the system. The take-homes from the hearsay evidence framework is that, as I said, it can go into evidence, but it may not be probative. It may not be given any weight at all, or it will be given little weight. It can be ruled upon when there are objections to be considered that it will prejudice a case or be dangerous in some circumstances. So that's important to know, that even if your report gets in, it may not be useful. You'll see that Justice O'Brien looked there, and I won't leave that up too long, but it's in my paper about what I just said about Mr. Leo's report, and then you'll see in the second paragraph that he has comments to make about Dr. Corrigan's report for the overlapping Kajijiban claim. I won't read you about the Evidence Act and what it involves, but it is very important, as I said, to know that if you have observed things, if they back up and provide a basis for the information that you're gathering, and those documents either do that or don't do that, then you should put that in your report and give the warts and all view. And that's what Justice O'Brien said that Nell Taylor, the young anthropologist, did in the Dimer case. He said that she said, well, I don't know all of that stuff. She was very honest about what she didn't know. He said that she had thoroughly researched what she had done. She was very aware of what was going on in her report and in the documents and how she'd analysed them, but she was also, warts and all, about her approach on what was wrong with some of the documents, how reliable they were or unreliable they were. Now, what Mr. Leo did is he changed his mind at the end of his evidence. And just before he was giving evidence, he put on a second report, or at least his clients did, the Cooper family, which had him changing his mind. Now, you all know, if you've read the Code of Conduct, that if you do change your position, and this can happen, documents can come about at the last minute, new informants can come along that will make you change or shift your position, then you have to tell the court as soon as possible. You have a duty to the court to do that, because you're writing the report to assist the court. You're not writing the report to win the case for your client. So it's very important, if you change your position, to tell the court that. In this case, Mr. Leo did that, and he didn't provide an explanation for why he changed his mind or what had changed his mind. Now, of course, that's important. And the same thing happened in Smallwood in relation to Lottie, the apical ancestor I referred to earlier. Was she Bindle or was she not? The anthropologists had a conclave, expert conference. They dealt with a series of propositions, and none of them could say definitely whether Lottie was Bindle or not. Roughly a week or two before the concurrent evidence was due to be given, Lottie's, the people who were the descendants of Lottie, so a family called the Limb Burners, who had briefed Dr. Fergie. Dr. Fergie put on a second report changing her opinion. Very, very similar to Mr. Leo, different facts, of course, but in that report, she then resiled from the fact that she was not certain. She became very certain, but again did not provide reasons or a basis for her opinion as to why she had changed her opinion. And of course, it's just so important to do that, or otherwise you just lose the confidence of the court, which happened in both cases, with the change with Mr. Leo and the change with Dr. Fergie in Smallwood. And it's so important. And I'd like to think if Vance or I were briefing you, I wouldn't let you do that. I would make sure that if you had changed your opinion, you should absolutely tell the court, but you should tell the court why and what you'd found that had changed your mind. And so they're the take-homes, but you've got my paper, and yeah, I hope that's been helpful. But again, no criticism of anyone I'm just telling you what the courts have said recently, and it's very, very difficult for people to put themselves up in that way, but I encourage you all to try, the younger ones, to come forward and, yeah. So we'll hold your hand. Okay, thank you.